Yo, Jonathan Pollard, Florida employment lawyer. I'm going to tell you the number one rule for discrimination and retaliation cases. Always be suing, okay? ABS, always be suing fools, real proper like, okay? And I'm going to tell you why. So you can take this to the Chamber of Commerce and corporate America, the insurance companies, their cronies, including the judges who are friendly with them. You can take it to everybody. I don't care, okay? This is the reality of the system, and this is how the sausage is made in America. It's not a justice system, folks. It's a legal system. So get that through your head. Number one, threshold, okay? I am only talking about real cases. If you don't have a real case, don't bring it to me, okay? And I'm going to tell you right now, there is a difference between a case and a grievance. I've written about this. I have blogs on it, videos on it. I have an article in Business Insider about this. The laws exist to protect your rights. Your rights are not the same thing as your feelings. Just because your feelings are hurt does not mean your rights have been violated. Something might be unfair. Something might be mean. It might be not nice, but it doesn't amount to a violation of your legal rights. So I'm talking about real cases, folks. Real discrimination. Racism, age discrimination, sex discrimination, disability discrimination, religious discrimination. Cases where you have been blatantly discriminated against, where there was bigotry, it's clear, it's obvious. I'm talking about real, strong, matter-of-fact cases, okay? In those types of cases, for the most part, you just need to file a lawsuit. If you're going to vindicate your rights, get a reasonable resolution, and certainly if you want to maximize your opportunities in the case. Why do I say this? In many instances, okay, plaintiff side employment lawyers, they just don't want to put in the work, okay? And I know, right, I'm violating all these rules, these unspoken rules of law, right? The omerta, I'm not supposed to talk badly about other lawyers. Certainly not my brethren who also represent working people. Well, no, right? I call real shots on everybody. I call real shots on plaintiff side employment lawyers. I call real shots on corporate America. I am an equal opportunity shot caller. And the reality is there are a whole lot of lawyers who represent employees and working people who just want to make a quick buck. They want to settle the case as quickly as they can for chump change or a modest amount of money. Some lawyers and law firms don't ever file lawsuits. They're not willing to file a lawsuit in court. They're only willing to engage in pre-suit negotiation. That's it. If it needs to go beyond that, they can't help you, right? I've had countless folks contact our firm and wind up becoming our clients who originally worked with another lawyer or law firm, and that lawyer or law firm wanted them to settle their case, right? I've had situations where another lawyer or law firm wanted a client to settle a case for 30 grand, and we wound up getting $1 million for that case, right? I've done that, okay? I've had countless situations where wanted to settle a case for, 20 grand, 50 grand, 70 grand, and we wind up recovering multiples of those numbers. So this sort of thing, this is routine fare, okay? This happens all the time. Why? Because most plaintiff side employment lawyers don't want to do the work. And even if they are willing to file a lawsuit, they're just not willing to go through the litigation process. And let's take a step back and let's talk about what that looks like, okay? And I need you to just be real, okay? Be real and be fair about this and understand that when we file one of these cases, okay, let's just talk about what that looks like from a time and cost standpoint, because time is not free, okay? Time is not free. These cases are done on a contingency fee basis. Just because you are not getting a bill for the attorney's time does not mean that time is free, okay? We have cases, right? We have cases where we have clients who have many millions of dollars, and these are different types of cases. We're not talking about employment discrimination, et cetera. We're talking about more commercial business cases. We have cases where clients have paid us several $100,000, even $1 million to represent them in litigation, okay? So if you take what we charge in those cases and you sort of compare the amount of work, right? Like, we have employment cases where if that was litigation for a paying client, the client will be paying us $400,000, $500,000, $600,000, $800,000, right? That time is not free. That time costs money. In addition to the time, you have the out-of-pocket costs. It costs $400 to file a case, a couple bucks to get a process server. Sometimes you got to track people down, serve subpoenas. You take depositions, you buy a transcript. It was a long deposition. It cost $2,000 to buy a transcript. You took 6 depositions. You got $10,000 worth of transcripts. You got Westlaw charges. You got PACER charges. You got background check fees, witness subpoena fees, travel expenses. You got a client who, can't afford a hotel, right? Where it's like, you got to be here for your deposition, right? Where we have to, right? We have to pay the cost of like, okay, we got to fly the client here. The client, right? Say the client's out of town, okay? They moved because they went broke, got evicted or whatever, right? We're homeless. They're living somewhere else. Well, we got to pay to go get the client and bring them here, right? Got to put them on a plane, got to send a car service, okay? It's all just expenses, right? We routinely have cases with $10,000, $15,000, $20,000, $25,000 of out-of-pocket hard costs that we have to front, okay? Not to mention the time, not to mention 12, 15, 18 months in litigation, 24 months, 2 years in litigation, okay? So it makes sense that a lot of lawyers and law firms on the plaintiff side, on the employee side, just aren't willing to do that. They're not willing to do that. And the first sniff they get of $50,000, $75,000, $100,000 in a real case, okay? Folks, darn it, I mean it, all right? If you don't have a real case, if your case is trash from a legal standpoint, and I'm not saying something mean didn't happen or there wasn't some unfairness, I'm saying you don't have a real case from a legal standpoint. Your case would never make it. Your case is not worth investing in, right? And if you insist it is and pound on the table and throw a hissy fit, that's just entitlement and you definitely disqualified yourself. But in a real case, if these lawyers even sniff 50, 75, let alone 100 grand, they're tapping. They're tapping. Why are they tapping? Are they tapping because it's truly what is best for the client? Because the client says, okay, that's a lot of money. Take out attorney's fees and costs. I'll still get 30 grand. That's huge to me. I want to settle right now. That's definitely my choice. Or is it because the lawyer said, look, this is the best you're going to get. Take this money right now and run. And then the lawyer said, okay, right? Put virtually no work into this case, and I got 100 more like that, right? On to the next one. That's a business model. But that's not my business model. That's also not my philosophical model. That's not my crusade model, because I'm a crusader, right? I'm a renegade. I'm a revolutionary. Everybody knows it. Let's talk about discovery, okay? And this is where the sausage is really made. We've had so many cases where at the outset of the case, we say, okay, we think the case is pretty strong. We get into litigation. The company on the other side fights tooth and nail to hold back evidence. Because, see, in the American litigation process, you're supposed to turn over any relevant evidence to the other side, okay? Whether it's good or bad for your case, And people, the system, right? The system is corrupt and dysfunctional and everything else, okay? And routinely fails. But if we believe in the system and we want the system to work, the only way it can work fairly is if everybody turns over the relevant evidence, good or bad for them, right? So we can have a trial and focus on what's true, what really happened, right? Like, as much as I can't stand corporate America and its machinations, I'm not for any shenanigans, right? I'm not for playing dirty, cheating, obtaining an unfair advantage, and pulling a fast one. Like that's not my style. Okay, I take real cases. I take real flipping cases. And in these cases, invariably, we get into discovery, and the corporate playbook is basically to stall, stonewall, refuse to hand over documents for as long as they can, and possibly forever. Okay, we've been involved in a number of cases where, let's take an example, right? Say it's a race discrimination case, and we want all of the complaints, employee complaints about race discrimination at this particular office or factory or location during the time when our client, the employee, worked there, right? Pretty reasonable, okay? Our employee, right, our client is complaining about racism, and she says it was terrible, and there were a whole bunch of other incidents, right, with racism, people saying the N-word, racial harassment, et cetera, and we just want the complaints from the same time period, right? What other employees were complaining, right? What did HR know? What sort of investigations did they do? How were these claims treated? Were people retaliated against? We have every right to this information. In fact, courts have routinely said that this type of information is critical, relevant, central to proving a race discrimination claim at trial. They've said it's highly relevant. You have to turn it over. Well, it should come as no surprise that corporate America routinely refuses to turn this type of information over. So we have to spend the time we have to request it, we have to confer with them, we have to go back and forth 16 times, we have to give them ultimatums. When they finally stand on their refusal to produce it, we have to file a motion explaining why we want to compel it. You cite all the law, we do a hearing, we argue to a judge compels it, we have to wait for them to produce it, we go through the documents they produced, we make sure it's all there, we make sure it's not redacted improperly. If it's not all there, we have to go back and compel more. If it's redacted, we have to go compel again. It takes time and money. And most plaintiff-side employment lawyers are just not willing to go through the process. They're not willing to go through the process, and they're hedging against a possible loss. I'm not really hedging against the loss. And so for the same people who throw temper tantrums because my firm won't represent them, we get 400 or 500 inquiries a week. Of course I'm not representing 95% of the people who contact us. And that's not unfair of me, okay? It's not unfair of me. Because the cases that we select and that we pursue, we are 100% committed to, and we are not hedging against the loss. We are not hedging. We are going all in on these cases. And there's a significant difference. You cannot expect a lawyer, my caliber, my level of commitment, willing to go the distance. You cannot expect a lawyer like that to commit to your case and go all in unless it's a very strong case. But if it is a very strong case, then that is the only way to maximize your position. Because companies will only get real, get religion, and come to their senses when you do the work, you show them you're not afraid of the work, you're not afraid of the time, you're not afraid of the expense, you will go the distance, and you will do everything that it takes to get all that you need, to get all the evidence, to get all the discovery you're entitled to. You will put in the work, you will put in the hours, you will pay the many thousands of dollars. And whatever they do, right, whatever shenanigans they engage in, whatever roadblocks and obstacles throw up, whatever nonsense they pull, whatever Bush League tactics, you'll just ride through it. You just ride through it and just keep going. Okay? You just keep going. The bottom line there is, in the vast majority of cases, you just can't settle the case pre-suit. Talking employment discrimination, retaliation cases. The exception here is certain cases involving sexual harassment and outright sexual assault. We routinely settle those pre-suit. Particularly where they are very, very ugly. But on the flip side, there are always Fortune 500 companies who we approach with a very ugly sexual harassment, sexual assault case, and they just want to gamble and take the action, where they're basically like, we're a big company, we got $1 billion or more. What are you going to do to us, right? We can drag this litigation out for years. Let's go. Come on, right? Wildly enough, like that sort of approach of like this sort of cocky good old boy network who's like, yeah, sue us. We got billions. That tends to be very, very prevalent among big companies that emerged out of the South. It is so common, right? So common. Like you go to a company that emerged out of I'm not saying this is universal, but it's interesting. You go to a company that emerged out of New York, the Northeast, right, with a very ugly sex assault case or a very ugly sexual harassment case. They're basically like, we get it, let's deal, right? You go to a Florida or Texas company, right? A company merged out of Florida or Texas, dominated by good old boys. They're like, we got a lot of money, we're tough, so let's do it, buddy. Let's go, right? And then we see what that gets them, right? We're gonna see real soon. We're gonna see in January. It's gonna be real hot. It's gonna be the new hotness. But that's the deal. Other than those types of cases, for the most part, in discrimination, retaliations, or whistleblower cases, etc., you're not going to maximize your position unless you not only file a lawsuit, but commit to the process, including the discovery process. And not a lot of plaintiff side employment lawyers are willing to do that. We've routinely had opposing counsel, we've routinely had corporate lawyers comment to us that they've never gone up against a plaintiff side employment lawyer who treated the case the way we do, who litigated it as aggressively as we do, and who litigated it like it was a case that we were being paid for, meaning being paid hourly. That should tell you something, right? Am I just a foaming at the mouth, sweaty tooth madman? Okay. Am I just an unmitigated crazy person who doesn't know what I'm doing and am destined to fail spectacularly and get my comeuppance? Is that the real? Why would I be investing millions of dollars in these cases, right? Because it's not just one case, right? It's dozens of these cases, right? Literally cost millions of dollars. Why would I have invested millions of dollars in doing this? Any one case between attorney time and out-of-pocket expenses is easily $300,000-$400,000. Why would I be investing all of that? Why would I be doing all of that? If it wasn't going to work. You got to commit to the process. You got to trust the process. You got to go the distance. It's the only way you maximize your position. Jonathan Pollard, have a great day. Have a great weekend. Peace.